In this edition of the Montana Majority Report's Insider Updates, Senator Wylie Galt sits down with Senator Becky Beard to discuss Senate Bill 263, aimed at stopping the state from taking water rights on leased land and limiting its claims on water improvements. Listen in.
Well, hello, and I would like to first introduce myself, Wylie Galt. I'm the senator out of central Montana, and with me today I have Senator Becky Beard, the other side of the divide over here, and she is bringing a bill that I think is probably one of the most paramount bills that we have in this session for water right holders. So Senator Beard, would you explain your bill a little bit?
Well, thank you, Senator Galt. Senate Bill 263 is the bill in question, and it kind of takes off in strengthening what a former representative in 2019 started with his bill. And what we're doing is we're just putting our foot down and confirming that our water rights, our privately held water rights, are ours. This is a property rights issue. And we are not going to let any agency, establish how we can dictate our own water rights. Going way back in the early history of our state, the first in had the first right. And that's what we have based our agri community and industry on. So we want to stick with that. And a decree was filed prior to 1973. And statement of claim between 1979 and 82, saying that the state had a right to hear water rights with the land board, and it was not incorporating any public participation of owner rights into that process. What needs to occur is to have the land board come in and talk with the property rights owner, the water rights owner first, and provide that forum in which to discuss who has the first in, first right water right.
Yeah, I mean, the genesis of this is, I think the only way to describe it is some tomfoolery that happened back in 19, where you had the state coming in and stealing people's water rights, laying claim to them. I mean, what we need to make it clear is we've all seen through this process. I know we were just young little House members back when all of this happened the first time around. But it is just a complete erosion of private property rights that the government was doing here. To come in, landowner trying to help out, trying to, add value to a state land, and then getting punished for it just seemed like a huge leap over the line.
That's absolutely right. And we want to, with this bill, this session, just establish that we will codify the state's accountability into law, so we have a premise reestablished that we have those rights.
Yeah, and I think if you just boil down what this bill does, it just puts more eyes, elected eyes, onto a problem, and it's just not a department laying claim behind closed doors.
And it doesn't matter how many people interpret the law on the books. We are the elected officials who can come in and establish what the law is going forward, or to clarify how the law was written back then and just redefine it, make sure that people understand that we have an interpretation that was intended to be in place, and we will maintain it in place going forward. And I just wanted to bring up an old saying that I remember our good Senator Max Baucus once used at every public presentation he was involved in. He said, "Whiskey's for drinking, water's for fighting." But do you know who first used that phrase?
I do not know who coined that one.
Samuel Clemens. Mark Twain.
Oh, wow.
Yeah. So we're seeing it again in the state of Montana, and not just with water rights, but property rights overall. So we're getting downright crispy that we want to stand up for our rights in this state. We are an ag industry-based state, and we're going to make sure we keep it.
Yeah, and if I remember correctly, he said what this bill does, it just kind of codifies a motion that was before the land board. And if I remember correctly, it was a unanimous vote for it.
Absolutely. But there and again, we have people going back and reinterpreting, almost recreating what was said on the record.
Yeah, and I was reading somewhere, I think it was that we do have some precedent with this. That I think it was an 86 court case that claimed that the state can't do this. But just like you were saying again, over time, people interpret it different, and we find ourselves back to where we have the state taking water rights again.
So there goes. We need the land board to stand up and allow we, the citizens, to state our case. And then based upon what case is stated, then the state may come in and make sure that we follow the law? I don't know, but we make the law. And those laws are set in place so everybody has their right.
Yeah, and I think we can all agree that if there's gray areas in water all over the place. So that if something like this happens, that it's in front of a group of our land board, our 5 constitutional offices, with public input so that it can be brought out, all the facts can be figured out in the light of day.
We don't have to have the state executive agencies telling us how it's interpreted.
Yeah, and I know you hear some of it out there that it's already codified. We already did this motion. What are your feelings on that narrative?
Yeah, well, if they've codified it, if they're interpreting the codification not to the intent that it was established, then I think that's our perfect opportunity. It's our responsibility to go in there and clarify the statute and or redefine it based upon 150 elected legislators in the state to establish what the statute should read, how it should read, and how it's clarified.
I could not agree more. I mean, if this has been an issue, I think even if it is codified, to get it a little more clear in there is probably the right move to do so we're not dealing with this 10 years down the road again.
So there you have it. We have Senate Bill 263.